WCNC Charlotte. This is Flashpoint, where power and politics collide and the tough questions get asked and answered.
An important race you'll be deciding on November 5th, the race for North Carolina's Supreme Court. North Carolina, one of just 7 states to hold a partisan Supreme Court election. In this year's election, Republican Jefferson Griffin, a current judge on the North Carolina Court of Appeals, is taking on Democrat Allison Riggs, the incumbent justice on the court, in what's expected to be a very tight race. Justice Riggs, thanks for joining us. We appreciate it.
Happy to be here. Thank you.
All right, full transparency with the folks at home. As a sitting justice, there are issues you can and can't talk about because they are either in front of you or could possibly be in front of the state Supreme Court. So just want to let people know that. With that said, how would you best describe your judicial philosophy, your approach to cases?
Yeah. So I'm a critical thinker who values transparency and empathy. It's become very popular lately for judicial candidates to, claim allegiance to one particular judicial philosophy. I think that's become code for political ideology and how you're going to vote. I think we've seen that in the last few elections. I don't ascribe to a one-size-fits-all judicial philosophy. Different philosophies provide us tools and mechanisms for understanding nuanced, complicated laws. And I'm a critical thinker. I'm a scientist by training, was a microbiology undergrad, and worked in a neurotoxicology lab. So I like to test a hypothesis, kick the tires from every angle. I'm very rigid, and the only thing I'm rigid about is my methodology. I think one of the ways that I am very successful in excluding external and improper influences is the order in which I read through cases. We're an appellate court, not a trial court, so we are reviewing trial court decisions. And so I'm very careful to look at the opinion that I'm being asked to review and sort of incrementally grow out the universe of information that I consider. But I understand that there are real people at the end of these cases, and they're important, and life and humans are complicated. The law is nuanced, and if the answers were easy, these jobs wouldn't be so hard fought for.
Sure. And I think it might strike some people as odd that our state Supreme Court justices run in partisan elections. It's been that way, then it wasn't that way. What are your thoughts on it?
Yeah, so we're the only state in the country that had partisan judicial elections up until the early 90s. The Democratic legislature then moved to nonpartisan elections, and we stayed that way for some time. 2018 was the first year that our North Carolina Supreme Court elections were partisan again. That's never happened. One of the critiques, obviously, of the judiciary, our judicial races right now, is that they have become partisan. But I tell folks I'm not a policymaker. The Republican legislature decided to make these races partisan. Those are the rules of the game under which I am forced to operate. The other thing that the Republican legislature did that I think impacts the public's perception and trust of the judiciary is they got rid of public financing for judicial elections. And so now you have judicial candidates asking lawyers for money. And when a citizen of North Carolina goes and looks at our campaign finance reports and sees, oh, these lawyers donate to this candidate and these lawyers donate to that candidate, I don't think that helps the perception of how impartial judges are. Now, obviously, I take very seriously my constitutional duty, and integrity is the most important thing to me. But, policymakers in the legislature decided this is how judicial elections should be run. And so I'm going to do my best to, make sure that that voters understand who I am, what my values are, and I'm going to speak freely about my values, not how I will rule in a case, but I care about the integrity and perception of the bench as well. So it's a balance beam I'm walking on every day.
Sure. Reproductive freedoms, a hot topic here across the country in some of our races as well. What can you say about how you approach that issue?
Yeah, I can tell people that I value reproductive freedom and share my personal story. I'm the youngest woman to ever serve on the North Carolina Supreme Court. I'm the only woman of childbearing age on either of our appellate courts, and I'm newlywed. My husband and I only married in 2021. My mother was over the moon happy that that finally happened. But we hope to start a family. But obviously at age 43, I know that I may need access to reproductive health care, whether it's fertility treatments and IVF, or if I lose a much wanted pregnancy, access to emergency health care in treating that. And when the United States Supreme Court overturned 50 years of precedent in Roe v. Wade and sent the issue back to the states, I understood that that meant that it was going to be sent back to state Supreme Courts. And so I think reproductive freedom is one of the major, if not the major issue for voters this year. And voters want to know that the people that they are electing to office, whether it's the executive, legislative, or judicial branch, that these are people with good sense and share their values and are committed to keeping women safe, trusting women. We're seeing women bleed out, become septic, and die in emergency room parking lots all across the South. And I want voters to know that I value women's ability to make good decisions, the best decisions for their families about their own bodies, and that voters in North Carolina can trust me with the immense power that a Supreme Court justice has, particularly when it comes to respecting those very personal rights.
You litigated Harper v. Hall when the North Carolina Supreme Court ruled that partisan gerrymandering was unconstitutional. That decision then overturned last year. What's the state of voting rights as you see it here in North Carolina?
Yeah, I'm very proud to have spent my entire career fighting to vindicate the Constitution. I worked on a variety of different issues, but obviously voting rights was a major one. The right to vote freely, without hindrance, without interference in unrigged, unpredetermined elections is a core right of every North Carolinian, and our Constitution provides protection for that. I obviously was proud to be part of the Harper v. Hall case, and Harper v. Hall has been overturned by this North Carolina Supreme Court. So I think, I think judicial elections are about accountability, and voters should go to the ballot box with information and understanding about whether sitting justices or judicial candidates are willing to stand up to political power without fear or favor to defend their constitutional rights, including the right to vote. And I can't say how I will rule in any upcoming case, but I'm very proud of my record. And I think, I've already heard my career described as one in which I filed political lawsuits. And my response to that is if a sitting judge dismisses lawsuits filed to vindicate constitutional rights as political lawsuits, that person is telling you right from the get-go that they are not going to give a fair and impartial hearing to a whole class of litigants seeking to protect their right to vote, and that's a problem.
All right, Justice Allison Riggs. Justice, thanks for coming on. We appreciate it.
Yeah, wonderful to join you today. Thank you so much.
All right. Now we hear from the Republican nominee, Judge Jefferson Griffin. Judge Jefferson Griffin joins us now. Judge, thanks for coming on. We appreciate it.
Good morning. Glad to be with you. Happy first day early voting.
That's right. That's right. All right. Right off the bat, not all of us are legal experts like you, but in the easiest way you can explain it, what is would you say your judicial philosophy when it comes to ruling on cases?
That's a great question, and one that we can't answer as jurists. We're limited by what we can talk about. We should never comment on issues that come before us, but we can talk about how we interpret the law, and that's something that voters in North Carolina should assess and ask of every judicial candidate. I apply the law as it's written consistently. I try to take the original intent of it, the original meaning, and apply it as it is written. There's a lot of other ideas about how to interpret the law, I guess, but I think applying as it's written, as of the time it was written, is the most consistent way to apply the law, because if I start putting my spin on words or my interpretation, it just invites judicial activism and legislating from the bench. So I believe my approach, applying it as it's written, is the most consistent with our founding. It's most consistent with our mission in the judicial branch, is to interpret the laws, not make new laws. And so that's how I look at cases.
Now let me ask you about politics, because you are running for office. The state Supreme Court has a Republican majority of 5-2, and we're considered a purple state. You know that. Unaffiliated voters and Democrats outnumber Republicans. Do you think a 6-1 Republican court would truly represent the state of North Carolina?
Yeah, I don't think our partisanship matters at all. I do believe it's more ideological as far as a conservative jurist versus a liberal jurist. And I think North Carolinians, if you look at conservative jurists in our state, they probably would like 7 because, it's not necessarily a political thing. It's an ideological judicial thing. And as I explained before, I think North Carolinians consistently have wanted judges who apply the law as it's written. And that's what a conservative judge does, where a liberal judge will say, well, the meaning of that word might have changed over time, or, certainly the legislature got that wrong. We, the judges, should be able to put our spin on that and move the law through the judicial process. And so as conservative jurists, I don't always agree with my conservative colleagues. There have been plenty of cases where I've written dissents, or we split on cases just because we were registered Republicans or have a similar conservative judicial philosophy. Does not mean we agree on everything. What I do say is that it tightens our window as jurists. It makes sure that we're not going outside our lane into the legislative branch, and I think that's a better way to look at it than partisanship. I'm all about removing politics from our courts. As a matter of fact, I don't think we should address. It's always interesting when we talk about judicial races or how a particular jurist or panel ruled on a case. It's always the narrative: is it a Republican or is it a Democrat judge? And I don't know that that's healthy for our state to report things that way.
To that point, though, I mean, not all states, most of them don't have partisan elections when it comes to state Supreme Court. We have had it that way and then didn't have it that way and have it that way again. Do you agree with our way of doing it?
That's a complete policy decision. That's up to the General Assembly. Our state constitution mandates that all judges in our state are elected. And so, we had a constitutional amendment in 2018, and having grown up in this state and lived here my whole life and practiced law and as a practicing attorney, prosecutor, district court judge, and appeals court judge, I think I know the voters of my state. They're never going to give up the right to vote on anything. So we're going to have judicial elections. Now, the best evidence of putting party labels on the ballot, what the effect is voter participation rises. In 2016, they had party labels next to the Court of Appeals races, but not the Supreme Court race. And when people look at their ballots here very soon, today or this, the next 20 days, they'll see that the Supreme Court race is above the Court of Appeals races on the ballot. And in that race in 2016, in that election cycle, 250,000 more people voted for the Court of Appeals races than they did in the Supreme Court race. So that means they skipped the Supreme Court race and went down the ballot, and 250,000 more voted for that because, I don't know what other reason you would find other than it had party labels on there. So it does give voters more information. And as y'all report, and a lot of people ask, they want to know how our registration is. So it's more information for the voters. But ultimately it's a policy decision by the General Assembly.
And inherently, as you know, and as we know, because we cover it the judicial races are often lower profile, and so some people might not know some of the names they see, which is why I think it's important that we're interviewing you. A couple of issues I want to ask you about, and for the folks at home, you may or may not want to answer these because I know there's a discomfort with answering questions based on issues when you're a sitting judge and you can rule on them. So I do understand that. That said, reproductive freedom's a big issue, not only here at the state, but across the country. You issued a ruling last year stating that life begins at conception. That ruling was later withdrawn. Without getting into specifics about how you'd rule on a case, what is your general stance on the issue now?
One, I didn't write that opinion. Two, I can't talk about deliberations of a court. Three, it was withdrawn. It doesn't exist anymore. And it didn't address the issue you're talking about anyway. But regardless, as jurists under our Code of Judicial Conduct, we can't address or opine on anything that may come before us in the court. You know, our law is settled in North Carolina. The General Assembly has spoken on the issue of abortion in our state. You're allowed to get an abortion up to 12 weeks with exceptions for rape, incest, life of the mother, fetal anomalies. And so that issue is settled. To the extent that any jurist or candidate for a judicial office wants to talk about issues that may come before them or how somebody else would vote on a case, that is a violation of our Code of Judicial Conduct.
And the same might apply to the next question. So I understand if you respectfully can't answer, but you have said in the past that the Leandro ruling was one of your proudest moments on the bench. It deals, for a lot of folks might not know, it deals with funding for low-income public schools. You stopped a move to move $1.7 billion to schools, not because of the case itself, I don't think, but because you say it should be up to lawmakers and not to a judge. Is that a fair assessment?
I don't know that I think that may be a misquote, that it was one of my proudest. I think it shows my judicial philosophy that I'm not going to legislate from the bench, that I respect the separation of powers in our state. Could you imagine what would happen if one trial court judge was allowed to appropriate money in our state? It's clearly in our Constitution that appropriation is the job of money, is the purview of the General Assembly, and that was simply what we did. We had a writ of prohibition in our court. Look, we actually explicitly said we followed an opinion from a Democrat justice, a more liberal justice that had already written one previously that said exactly that. And I think it highlights the importance of the separation of powers in our state. And we didn't disturb the trial court's findings. The trial court can make findings that, they believe that the schools are underfunded or whatever they may have decided to find there based off what was presented. We simply held at our court that jurists can't appropriate money. That's the job of the legislature. I think that's pretty plain and clear in our Constitution.
Like I say, these races don't get enough attention, especially on broadcast news TV. So I'm glad we've been able to have this short chat about some of the issues and some of your philosophy as well. Judge Jefferson Griffin. Judge, thanks for coming on. We do appreciate it.
Yeah, I would also just like to add, I will be on state active duty orders with the Guard here coming up. I serve in that capacity as well. I've authored over 250 opinions at our court, at the Court of Appeals. I've served as a trial court judge, prosecutor in our state as well. And I think I will be a value add. There's no former trial court judges on our Supreme Court. And that's an important perspective, having traveled the state, talking to other trial court judges and citizens that they want on the bench. So appreciate people's support. Thank you.
Sure. Judge, thank you for your service as well. Take care. As always, folks, come interact with us on social media. If there's something you want us to cover on Flashpoint, let us know. And as always, remember to listen and subscribe to our podcast. You can find it wherever you get yours.